That gives you a sense of the menu of options that state and local governments have, their choices when they're trying to decide how to deliver this service. Sometimes litigants come into court and they question the wisdom of that choice. You chose the wrong system, or you chose an okay system, but you're starving it to death. This kind of litigation has become a good bit more common over recent decades. But the idea here is that we're not litigating the effectiveness of a single lawyer. This is, in effect, system-wide challenges to the effectiveness of counsel. This litigation happens in a lot of places, but let's track one especially colorful and multi-part story from New Orleans, one of my favorite cities. My family lived there for a while. Let's start with State v. Pert. At this time in the early 90s in New Orleans, the system for providing defense counsel in the city was that the legislature had established something called an indigent defender board. And each board was to choose between a public defender or a contract attorney or an assigned counsel or some kind of mixed model. And so in New Orleans, the Orleans Indigent Defender Program used a public defender model. It was locally funded, and what's interesting is that the funding for this came from criminal violation assessments. You tack on a fee of $17.50 up to $25 per violation, except for parking violations. If there's a conviction, you tack on this fee goes into the defender fund. It turns out that this fund could only support the salary for so many public defenders, and so the public defenders ended up building up a larger and larger caseload. And at one point, an attorney working for the Indigent Defense Board, Rick Tessier in New Orleans, decided it's time to challenge this. And so he brings a claim on behalf of his client, Leonard Pert, and says, you're bringing criminal charges here, but you can't go forward because the system that is funding me to represent this guy is constitutionally inadequate. Why? Well, he says, I have 70 active felony cases at this moment. My clients are typically incarcerated anywhere between 30 and 70 days before I can even possibly meet with them. Or over the first 7 months of 1991, he says, I represented 418 defendants. Usually, he says, I have no investigators. There are 3 slots in our office, 3 investigator salary slots to cover 7,000 cases. Of course, I can't afford expert witnesses. There's an inadequate library. The list goes on and on. So his claim is this system is starving my defendants to death. Now, he doesn't make this claim under the U.S. Constitution. He makes it under the Louisiana Constitution, which has some interesting provisions that relate specifically to this setting. So Article 1, Section 13 guarantees the accused in that state the right to assistance of counsel, quote, at each stage of the proceedings. That's familiar from the Sixth Amendment. But also notice that it says that the legislature, quote, shall provide for a uniform system for securing and compensating qualified counsel for indigents. Stress there on that uniform system and stress on the qualified counsel. So what does the Louisiana Supreme Court do with this? They rule in favor of Leonard Pert, and their remedy is an interesting one. They say there's a rebuttable presumption of ineffective assistance, and it applies within this courtroom. Section E of the New Orleans courtroom. There are lots of different sections. If I remember right, it goes up to H or I. This rebuttable presumption of ineffective assistance could be rebutted by the state if they come in and show that despite the anemic funding, in this particular case, this lawyer is doing a terrific job. The interesting irony of the prosecutors coming in and praising the work of the defense attorneys, and the defense attorneys coming in and bad-mouthing their work because they don't have funding to do a proper job. The Supreme Court here did overturn the choice of remedies from the trial court, which were much more aggressive. The court had ordered a reduced caseload for Tessier and actually issued an order to the legislature to fund an improved library and an investigator for Tessier. And the trial court announced plans to make members of the bar other than the public defender's office represent future defendants while there was a cap on the caseloads of the existing PDs. And the Supreme Court says that's inappropriate at this time. The court says maybe later if the legislature doesn't respond and really listen to us, then we might have to use some more intrusive and specific measures. But for now, we'll go with our rebuttable presumption of ineffective assistance. By the way, you see here Rick Tessier standing on the courthouse steps. the famous Tulane Avenue courthouse in Orleans Parish, famous old courthouse that was the site of a conspiracy trial run by Jim Garrison, a district attorney for Orleans Parish back in the 1960s and 70s. Was the basis for an Oliver Stone movie, JFK, about a possible conspiracy behind the assassination of the president. So a building with an interesting history. After Tessier brings this suit in the 90s, of course, we have Hurricane Katrina that comes to town and floods the entire courthouse here, washes enough water into the basement to wipe out a lot of records in the courthouse. So quite a set of stories associated with this old building here still operating. The Pert ruling in 1993 was not the end of the story in New Orleans or Louisiana, not by a long shot. So in the short run, the case probably did some good. The legislature did start providing some annual state-level funding for the Indigent Defense Program. And so this statewide Indigent Defense Assistance Board provided supplementary funds in some cases, especially capital cases. Trouble was, after this initial response from the legislature to the Pert decision, started cutting funds over time, and so the state board funding was cut by 25% after the first year and really was never restored. It got bad enough that the legislature created a Louisiana task force on indigent defense services in 2004. But there's also litigation going on. There's a defendant in Calcasieu Parish, which is not New Orleans, but elsewhere in the state, who's represented by Ronald Ware, who was the chief public defender for Calcasieu Parish. But then Ware comes in and says, I have way too many cases. I can't handle this extra murder defendant. And so the court says, you're right. I'm going to pull you off of the case, and I'm going to appoint local attorney Phyllis Mann to represent this defendant. But Phyllis Mann says, wait a minute, I'm working on this defendant's case, and I'm running up hours, and I'm not getting paid for it. And so the trial court hears this claim by Phyllis Mann and the client, Adrian Citizen. And so the trial court orders the local government to supplement the anemic funds that the state has been providing in this case. So they say, local government or parish government, you have something called the parish police jury, which collects fines from criminal defendants. Normally, you distribute these funds to pay for witnesses and jury fees and that kind of thing, and you pay the leftover to the DAs and to the courts. But you're going to have to take some of those funds, says the trial court, and pay this attorney for the work she's doing on this case. Plus, the public defender, Ware, comes in and says, oh, by the way, the state owes us $47,000 for capital defense efforts we've already put in, and they've committed $150,000 in upcoming cases. And we think the local government ought to pay that as well, because the state is stiffing us. They're not giving us the money they owe us for past efforts and money that they have promised us for upcoming efforts. So the trial court agrees again and says, yep, $200,000 from the local parish police jury into the court registry, and we're going to distribute these to Phyllis Mann and to the public defender's office. The Louisiana Supreme Court comes along again and says, once again, we have a trial judge who, heart in the right place, but probably the wrong remedy. And so the court says, the statutes themselves are not unconstitutional. They do provide for some funding coming from the state, and some might come from the parishes, but they're not legally obligated to pay these expenses. It's just that they have been sometimes drawing from the police jury funds, but typically those go to other actors, not to the defense attorneys. And that's constitutionally acceptable under the state constitution, says the Louisiana Supreme Court. So they say it was an error for this judge to order this local money to go into criminal defense. The court also says, we really do hope that the legislature acts quickly on its task force recommendations, because things are looking pretty bad. And the court lowers the hammer in the last part of this decision and says, it is implicit in these defendants' constitutional right to have an adequate attorney who's provided adequate funds for the defense, that if you can't pay for the lawyer, you can't go forward with the case. So we're going to let any appointed lawyer file a motion to determine funding on the front end. And if the funding's not there to pay them, then you can file a motion to halt prosecution of the case. Notice here, things just seem to keep falling apart in Louisiana. It's not just Louisiana. This happens in lots of states. But notice the court comes in, orders something. It might help for a little while, but then the funding goes away. The court comes back in, orders something. By the way, on the topic of things fall apart, Rick Tessier, our hero in the Pert case, also gets in trouble later on because he fell behind in his continuing legal education obligations and was sanctioned by the state bar and had to get his act together for getting his CLE all lined up. So remember, complete your CLE. The Louisiana cases are not the only place where this kind of litigation comes up. You see news stories about them all the time. It's not that every state does it every year, but it's a common line of stories for somebody to file a court case asking the judge to order some changes in the system that would provide for better funding. Typically, these claims are filed under state constitutional provisions because the claim is somewhat in tension with Strickland v. Washington. Remember, Strickland v. Washington focused on the effectiveness of individual defense lawyers, looks after the fact, after the lawyer has acted, and it looks with a presumption of effectiveness. These cases are prospective. Before we even get into it, we know the funding is inadequate, and they sometimes result in a presumption of ineffectiveness. So there's some tension between Strickland and these cases, but that can be resolved if the state court bases its ruling on the state constitution. There are various doctrinal ways that parties try to distinguish away Strickland and say we're not really talking about the same thing. It is possible to make a Sixth Amendment-based claim that is an attack on the system and a prospective attack, but it would have to fall in the category of attorneys just not even being available, as opposed to the effectiveness or ineffectiveness of a single attorney. Finally, one other category of litigation that goes on here would be challenges by attorneys to the adequacy of the funds that they receive. This could be based on some kind of due process theory or, more interestingly, an unconstitutional taking of property without due process of law. You force me to work, I do the work, and then you're not paying me for my time at even a minimally acceptable rate. It's a taking of property. And occasionally these theories have found some success in state courts. When we get together next time, we'll talk about these alternative litigation theories and also talk about the choices that local governments make in how to organize and fund the defense lawyers that they have to provide. So I'll see you then.